And thanks for joining us today. It's great to be here and discuss this, what I think very interesting topic of public interest and the value in trusted data governance, and try to clarify what it might mean and why it's important. Just to give an outline of this brief talk, I'll first just give a background on the context of data governance, and particularly on the data sharing context and how that particularly impacts this notion of public interest in data governance. I'll try to say why public interest is important in health data governance, which will actually itself really help us inform what public interest actually is in this context. The why will help inform a sort of definition that I'll put forward. And then from that, once there's an understanding of public interest in this context, then we can discuss a bit about maybe how certain data governance structures can be designed to promote public interest, not only in data sharing and data use, and data gathering and other aspects of data governance. And just to acknowledge, this work is based on various papers and projects developed in collaboration with Angela Valentine, as well as informed by the results of the Social Science Research Thematic Grant Project, Health-Related Data Sharing from Good Governance to Public Trust. The PI, Tamara Lysot, Angela also involved in that, and various others involved in this conference today. But of course, any views and mistakes made in this presentation and subsequent comments are solely my own. Okay, so the context here, we're living in sort of the big data era. And what that means is there's large quantities of data about human health and individuals generated in clinics, of course, and research studies, and moreover linked to other data sources from economic, education, and other sites to try to improve understanding of health, human behavior, and interrelated aspects of the human condition. Now, this data can be used or shared for a variety of purposes, of course. We might have research studies, we might have service improvement, meaning companies or institutions such as higher education might look at data to try to improve their delivery of services to their own clients or their own students. You might have public health usage, especially relevant in the COVID-19 context, to contain outbreaks and monitor disease levels in a society. Of course, in commercial uses as well, in product development and marketing and so forth. And also a variety of different entities might use these different sorts of data, including governments, particularly maybe in the public health realm in this area of health data, universities, wide amount of academic research that's being utilized, hospitals, which might engage in both research and service improvement for their own patients as well as future patients, and of course, again, companies for product development, marketing, and related uses. So that's sort of the ecosystem in which health data governance comes to bear. And health data governance, at least as understood in this, for the purpose of this talk, relates to the rules, principles, mechanisms relating to the gathering, use, storage, and sharing of data. I've underlined sharing there because I'll be focusing a bit on the sharing context, partly because some of that research that I mentioned earlier, this talk is focused on data sharing, and the concept of public interest has been of particular relevance for data sharing. But I think the principles discussed today will be relevant to other data uses as well. Data governance, of course, involves a number of different aspects of data, including consent for the gathering, use, sharing, and storage of data security protocols to prevent data breaches, to ensure that only people authorized have access to it, as well as anonymization techniques to remove identifiers from data. But public interest actually plays a somewhat central role in various paradigmatic characterizations of data governance. And just to illustrate this in the data sharing context, the term public interest isn't always used, but a sort of cognate or a general sense of a similar sort of concept is deployed in almost any framework that you'll find that's looking at data governance, data sharing, or most other aspects of data governance. So for example, the Global Alliance for Genomics and Health, they have a set of 4 foundational principles for responsible sharing of genomic and health-related data, and one of them is promote health, well-being, and fair distribution of benefits, a sort of social benefit goal. The World Medical Association, its Declaration of Taipei, a sort of follow-up to the Declaration of Helsinki, states that research in other health databases and biobanks related activities should contribute to the benefit of society, in particular public health objectives. And WMA, as an international organization, society can be understood globally. There's the Chatham House, which maybe is most famous for the Chatham House rules of contributions to group discussions, but they also have a series of other useful guidance, including on principles of sharing public health data. And one of those principles, one of those 4 principles, is social value. There's also a very useful survey article just to encapsulate a more systematic way of trying to survey the different frameworks of data governance. So Kaufman et al. In 2019 had a nice article, Responsible Data Sharing in International Health Research. And one of the 4 themes they identified from these various documents, articles, frameworks, was social benefits and value. Again, all these are different terms, but I think they're revolving around a similar class of concepts that I'm going to characterize for now under public interest. And again, public, not necessarily referring to one specific country, but could be concerning a variety of different publics. We'll talk more a bit about that scope in the end later on. And I just want to say this sort of approach of the centrality of public interest really resonates in Singapore. And I'll draw on some results from the studies that social science thematic research grant that we conducted in Singapore. We conducted focus groups, small group discussions among lay public concerning thoughts about data sharing programs for precision medicine. And there was an emphasis among respondents on the greater good. They talked about data sharing. One person called it basically for the goodness of humankind and the world. You can read about that. That's been published in BMC Medical Ethics. Also, 2 more studies results are forthcoming. One from a survey, something called a conjoint analysis, where we analyzed a series of different components of a data sharing proposal and to see which components are more or less relevant. And users, so who is using the data, and uses, for what purpose, were seen as the 2 of the most relevant factors for sharing acceptability. And both users and uses, who is using it and for what purposes, has a substantial intersection with the public interest, right? So, uses like for research and by public entities like governments were seen as more favorable than uses for profit and users like private companies. And linking that with the focus group results, the implication that we drew from that was that there was a sense of more limited confidence in the sharing, advancing the public interest for such private users and private uses. We also conducted a citizens jury, which is a very intensive group deliberative exercise, or a group of individuals are brought together, given sort of testimony relating to this area of data sharing, and given evidence to deliberate over this question of under what conditions, if any, should data be shared with the private industries, because we realized from that previous work there was a lot of concern about sharing with private entities. And one of the recommendations, the first one that was ordered in the results, was that all sharing with private industry should be in the public interest of Singaporeans. Again, those are the results forthcoming, but clearly they actually use the language of public interest in restriction on how data should be shared. Health data in a precision medicine program should be shared with private industry. Okay, so why is it that public interest is deemed so important by these international bodies, as well as Singaporeans and others around the world? Well, I think the easiest way to understand this is that any use of health data needs ethical justification, right? And why does it need ethical justification? Well, for one thing, there's always a risk. Whenever data, particularly identifiable data, is used, there's a risk of a breach. There's a risk of researcher misuse. There's also a risk that the research could actually end up having effects that are deleterious to society if the results are misinterpreted, if they stigmatize certain groups and so forth. So it's risks not just to the individual involved in the study, but also these kinds of social risks for certain types of study, particularly with sensitive information. And for example, with population level genomic studies that look at ancestry data and try to draw ancestry traces, you might find that certain implications concerning ethnic groups could have unexpected and unanticipated ramifications for their perceptions of each other in different contexts. There's also going to be a certain sort of personal stake individuals have in particularly identifiable data. It is data about them, data that they gathered maybe in clinic or hospital, or maybe in the research context. But it is, maybe they don't own the data per se, but the fact that it relates to them in a certain way gives them an interest in determining how it is used and how it turns out. There's also a sort of resource use, resources in terms of financial resources and manpower, particularly for public sector, but even, and particularly when this is particularly relevant when you have public, public research entities, publicly funded research entities, sharing data with private industry. There's this question of good stewardship over those resources. So consent, which typically might be a way to provide this ethical justification for those risks, has limited normative force, right? Limited justificatory force. First of all, there's well-documented limitations on understanding. Even though we can provide informed consent, particularly in data sciences, there might be limited understanding of the different ways data might be used, of the risk profile, of what is at stake and the type of benefits that can accrue from this sort of data research. The scope of such consent is often broad, meaning it often is used one kind of consent at the outset for a variety of potentially different future studies, unspecified at the outset. And there's this ongoing debate about whether broad consent is really informed consent. And one kind of paradigm that's emerged is that kind of consent is really consent for a research study. Broad consent, I should say, is not consent for a research study per se, but consent for a sort of governance arrangement, right? But that kicks the can down the road away from the consent, active consent to ensuring responsible use of data to the data governance entities. And of course, they'll have to pick up the slack of ensuring that the data use is responsible and in line with the reasonable expectations of participants. In addition, explicit consent, even broad consent, isn't always obtainable for data sources, particularly secondary data sources, and gathered in a context when research and other uses were not envisaged. And sometimes even that consent might not be desirable if consent would bias the study in a certain way. Okay, so public interest can be seen then as a justifier of data use, of data sharing, and so forth. And this is actually reflected, I think, in the legal regimes in Singapore and other jurisdictions. So under the Singapore's Personal Data Protection Act, the default is for identifiable data, you need consent. But public interest is one of the bases as an exemption to that consent. It's therefore a basis, a justification for why you might not need to obtain consent for a given data use. Interesting, in Europe, the GDPR, the General Data Protection Regulation, it has a somewhat similar approach, but that's actually framed in a conceptually different way. Public interest is one of several lawful bases of processing data. Another lawful basis is consent, for example. So whereas in Singapore, consent is the default and public interest is the exception, in Europe, public interest is kind of on a par with other justificatory frameworks. Nevertheless, for both, public interest plays an important role in the justification of certain uses of data, including data sharing. So again, the normative role here of public interest is this justificatory role, that it can give moral reason for the permissibility of using data in a certain way. And to be clear, this is not mutually exclusive. What I mean by that is to say that public interest has a more justificatory role doesn't mean consent has no role. So it might be that you have an imperfect role of consent, but still a role for consent. And public interest and consent can work together to both provide contributory reasons why it's permissible to use data in a certain context. But the greater the justificatory basis you have, the stronger the basis. That is, the stronger the consent, the more the public interest advanced by a given use. That might be mean you can license greater potential risk of data uses, maybe greater sensitivity of the data use, and so forth. And then conversely, absence of certain factors, such as consent, if consent is not obtained for some reason, or is not of high quality, that might mean you have to rely more on other factors. So for a given sort of set of risks, if you have a limitation on consent, you might need a stronger public interest justification for that data use. And that's a sort of normative underpinning that's reflected by the provisions of the law, which allow public interest to justify use when consent is not obtained. Okay, so then now that we have that kind of justificatory role, we can try to answer this general question of what is the public interest. And I think it'll just focus on two factors here that are important given that justificatory role. One is that public interest has to be broad in scope, which means it has to be broad enough to sufficient on its own to justify data use, sharing, and so forth. What that means is it has to include all sorts of potential kinds of benefits in it, social benefits. So not just health benefits, but also potentially economic benefits, psychological benefits, benefits to social cohesion, and so forth, as well as maybe monetary benefits to society. It could also include improvements in social equity, if it can address inequities in society. It also has to apply potentially to a wide array of different populations. So this is what gets us to the scope of who are the publics involved, and those benefits could accrue to small communities, a subset of the population, could accrue to whole nations, or the humanity at large. And depending on the extent to which they benefit, the magnitude of those benefits might provide more or less justification for certain data uses and certain scope of data sharing. Now, this kind of broad scope has some downsides. It might mean that it's difficult, because of the broadness of the concept of public interest, it's difficult for governance structures to concretely implement such a broad concept of public interest. And that might be true. I think this isn't something that's been pointed out in response to Angela and my work. But one thing to note is that actually foundational principles, which are common in biomedical ethics, they often have this sort of character of this broad-based principle that doesn't really specify how to instantiate it. But nevertheless, those kind of broad-based principles can be useful in informing further specification and context. And that specification of the broad concept of public interest will depend partly on the pragmatics of a given situation, what's achievable in terms of public interest, what sort of publics can potentially benefit in a given project, and what is measurable, what is anticipatable, and so forth. So it'll depend on the context how this concept is narrowed down, but we need to have a common foundation before we can narrow down those pragmatic details. Now, just in the remaining time, a few implications of this account of public interests. So one is that we already have a number of legal regimes that require public interest assessments for identifiable use or sharing of data without consent. So in Singapore, under the Human Biomedical Research Act, as well as the Personal Data Protection Act, there are these provisions. But if this account is right, the public interest should come in also for even studies where there is consent obtained, and generally used for data and sharing, because there is this proportionality point, right? Now, the bar might be lower in terms of the public interest needed to justify anonymous research, for example, and consented data. But because it can play some justificatory role in the use of data and the permissibility of data use over and above just merely the fact that someone consented to it, there might be a need for this kind of role for public interest, particularly if broad consent for data uses is really consent for governance, and therefore consent for governance that would, to some extent, assess public interest of the resultant data uses. Now, that does lead to a problem, of course, of a governance body is needing to assess a variety of very complex factors, the broadness of the problem, and that can lead to inconsistency and variability in assessment. So there are going to need to be some assurance of consistency and transparency. And one way to try to accomplish that is to have governance bodies develop paradigmatic case studies, to have different bodies evaluate similar case studies, try to come to consensus, promulgate that consensus to the public, to allow for broader scrutiny and generate a rough consensus on which to operate. There's also going to be, though, implications for public trust. Again, that's sort of the theme of this conference. So public trust in data governance is then, because of this assumption of public interest as being one of the main drivers behind data use, public trust will rely to some extent on confidence that data use and sharing will be in the public interest. So the extent to which the public will trust may, of course, depend on background trust in the institutions, as well as the trustworthiness of those institutions, that is, how reliable those institutions are living up to the reasonable expectations of the population, including in terms of how they're going to ensure data is used in the public interest. It's also going to depend on the extent to which those institutions have set up procedures and processes to assess the public interest in a reliable, robust way. And that will mean, there's different processes that can be envisaged. But one thing that's going to be important for maintaining public trust is that as those processes are developed to identify public interest, what uses are and are not in public interest, there needs to be continuous substantial engagement with public and participation in this process to promote the alignment between public expectations and actual data use and governance. I think we'll talk more about some of those public engagement implications in the session tomorrow. But for now, just to flag this as a relevant issue in public interest assessments as well. Okay, so that's all for my primer here on public interests. Thanks for your time, and I look forward to our discussion.
All right, thank you so much for that, Owen. And now it's my delight to introduce Graeme Laurie. So Graeme Laurie is a professorial fellow at the School of Law at the University of Edinburgh, but he's not joining us from Edinburgh. He can tell us where he's speaking to us from today. And he has recognised as having a world expert in relation to privacy and public interest and how those two concepts intersect. We were delighted to have him as the co-chair of a working group, an international working group based at the National University of Singapore that delivered a decision-making framework on big data in 2019. And I had the privilege of working with him then. So I'm really interested to hear what you have to say, Graeme.
Thank you, Angela, and thanks very much in particular to Owen for his excellent presentation. So in the time that I have, I would like to make sort of 3 reflections in response to Owen. The first is on this tricky question of public interest. What does it mean? The second point I want to kind of cover is, I think, on the more valuable question of what work does public interest do for us in governance terms, particularly relating to data sharing that Owen flagged up. And thirdly, I would like to make some comments on the relationship between public interest and good governance, especially when it comes to demonstrating trustworthiness by decision-making bodies. So on the first point, public interest, what does it mean? Owen gave us some excellent coverage there of potential ways in which it can be very broad and the kinds of considerations that can be thrown into the mix when we're trying to answer that question. I think that for the purposes of this virtual conference, we have to be careful. I think it's crucial not to get too hung up on this question of what does it mean, because there's no definitive answer. As Owen was alluding to at various junctures in his talk, public interest is highly context specific. It's entirely dependent on the circumstances in which we're asking public interest to do some work for us as a decision-making tool. And I think what can sometimes happen in our broader discussions about the public interest is it can be seen as or constructed as almost some social truth that's out there that just needs to be revealed. And once we reveal it, then it can be applied and we answer, or we can address many of our social, ethical and legal challenges. And I don't think that's the case at all. I think it's important for us to recall that public interest is a social construct. It is created by us, and therefore we need to have that as a central feature of any discussions we have about what does it mean. Something I would also add into the mix is that any given context where we're asking what's at stake, usually there are multiple public interests that can be constructed. There are multiple public interests that are in play, and sometimes they potentially conflict. So in discussing public interest, there's no such thing as the public interest. There may be many public interests, but when we're looking at the justificatory dimension that Owen referred to, we might want to ask, is it sufficient to find a public interest, or do we need multiple public interests, etc.? So public interest operates in multiple ways throughout a decision-making process, and I think that's really important. Sticking with what does it mean, Owen referred to social value, he referred to public goods, Tamara mentioned earlier on social license. A lot of these terms float around in these discussions. I think there's a lot of overlap between what they mean, but I think what's valuable for a conference such as this is to begin to unpack where's the overlap, but also how are they different. For me, for example, I wouldn't say that public interest is synonymous with social value. As a lawyer, public interest is very familiar to me. It comes up in so many different areas of law. Social value comes much more from the bioethical sphere. It's very central to discussions there. I think one of the challenges for us talking about public interest and what it means is when we come from different disciplinary backgrounds, we might think we're talking about the same thing, but we might actually be talking past each other. Particularly when we've got these similar but not exactly specific concepts floating around. So I think it's important to make sure that we're not talking past each other when we're trying to answer this question of what does it mean. So moving on to my second point about what work does it do, Owen did an excellent job laying out the ethical justification for public interest.
Actually, it sounds like Graeme has cut out there in terms of his connection. So what we might do is move on to our next discussant, and we can come back and hear the rest of Graeme's really insightful points after that, if we can reconnect him. Okay, so it's a real pleasure to be able to introduce Sarah Cheung. She's currently undertaking doctoral studies in politics at the University of Edinburgh, but she's previously worked at the University of Calgary and at Queen's University, working on topics in public health and surveillance. And her research explores social benefits and harms that arise from new digital technologies and how they're used and applied in public health. And she wrote a really interesting paper on public interest last year, and I'm looking forward to hearing her comments in relation to this. Oh, hi, sorry, Graeme, you've just come back in. We've just decided to, actually, if you're here, maybe we should continue with Graeme's comments.
Yes, what I was suggesting from the legal point of view is often public interest is set up in oppositional fashion to individual rights. It's seen as a way to justify encroachment on individual rights. So an example that Owen gave was consent is the default in Singapore, but public interest can come in as a trump value. However, in Europe, as you rightly pointed out with the GDPR, consent is one legal basis for processing data, but public interest is another one, and they're not in opposition to each other. And I think that it's important to recognize that protecting individual rights is also a public interest. And positioning public interest in an oppositional way, I think, is problematic and can get us stuck on the value of public interest as a decision-making tool. So for me, what does it do is it provides us with a very valuable decision-making tool, so long as we see it as in the right way. And I think something that it particularly does is, because it doesn't have a definitive meaning, it requires us to reflect and justify on how we are constructing and applying public interest in any given context. And that requires reflection and justification. And I think from an ethical perspective, it shows that public interest actually forces governance-making bodies, entities, institutions to do that reflection, to do that work, and to demonstrate their trustworthiness and how they apply public interest. That links to my final third point about trustworthiness. I completely agree with Owen about the importance of transparency and accountability. But this reflective part of public interest, I think, is particularly important. I think there are good examples of best practice around the world where decision-making bodies have relied on public interest. They have published summaries of their decisions and their reflections showing the rationale behind how they've applied public interest. I think that's really important. That can help to promote trustworthiness. I think that can also set up systems of precedent. So for future decision making with respect to data sharing, we can show how public interest has been constructed previously and ask whether it applies in a current context. But as Professor Tan pointed out right at the beginning, things change all the time, and our constructs of public interest change all the time, and therefore we always have to keep how we construct public interest under constant review.
Wonderful. Thanks so much, Graeme. It was really useful. Please, you could pop back in. Okay, so now I'm going to hand over to Sarah for her comments. And I'll just say to people, remind you that please use the Q&A function. So if you've got comments or thoughts or questions as we hear from these different discussants, pop those in the Q&A. Thanks.
Hello, I just want to say thank you very much for inviting me to this webinar event. It's exciting to be here, and thanks to Dr. Schaefer for his talk just now. So I feel that Dr. Schaefer's talk deals with what I think is a timely issue. What's the significance of this idea of public interest when it comes to the use, sharing of health data? And Dr. Schaefer's done a great job at summarizing some of the context in which data use is occurring and the reason why we need to involve this term public interest and bring it into play for the purposes of governance. So Dr. Schaefer points out that data is used for a variety of purposes. So we're recognizing that these are important functions for society to run, whether it's improving the delivery of healthcare services, research into diseases. And as Dr. Schaefer pointed out, COVID-19 is a key example of why health research is imperative for society. So the bottom line is we need data for our society to run, and public interest provides an ethical justification for the use of that data. So I just wanted to flag a couple of key points or themes that arise from this in the brief time that we have. Firstly, I think I'd argue that there's actually a bit of urgency around this issue of public interest right now, because the landscape has changed. Basically, there's a lot more data available and becoming available, as Dr. Schaefer and Dr. Tan noted. We're in the era of big data, and there's just a lot more impetus to do stuff, and there's a lot more opportunities that didn't exist before. So as Dr. Tan noted, in the realm of precision medicine, there's a lot more data involved, and we can really sort of drill down to individual molecular phenotypic information, and that is opening up a wide landscape of research possibilities. But these new technological developments, such as big data and AI, are contributing to what I think is a growing problem with consent. So it's kind of having this knock-on effect, which is that even if you kind of advocate for the use of consent as a governance framework, there's really concern in some research fields that it doesn't really do the job that it was intended for before. And as Dr. Schaefer noted, this is kind of a tricky area that's been discussed quite a bit, and various other law scholars working on the issue of consent with respect to big data kind of hold the view that broad consent doesn't really allow people to have meaningful control over their personal information. I think in particular the work of like Daniel Solov here, and also Helen Nissenbaum, who's noted that without building in narrowness of purpose, informed consent effectively equates to what she calls a blank check. However, if you're trying to build in that narrowness, you have a bit of a problem, because broad consent is what is most advantageous for research, and it takes into account how data mining and machine learning works. So consent doesn't actually work anymore. Potentially, the concept of public interest is becoming more important, which makes Dr. Schaefer's work very timely and important right now. The second issue that I was going to bring up, that Graeme's actually already alluded to, is really the tensions that play between different interests. Owen noted that typically the two frameworks used to access health data are consent or public interest, and Graeme's noticed that they're usually put into opposition, and you can frame it as whose interests are key, which group of people or individuals get to trump others, really. But this tension of interests also extends in a different direction as well, ties into an issue that Dr. Schaefer and his colleagues have explored in what looks to be very interesting survey work and their research in their citizens jury, which is even those who want to share data and do talk about how they want to contribute to public view, they have very distinct views, contribute to the public good. They have very distinct views and preferences on who's using the data and why. And I think a very interesting thing that could be explored here is to compare this with research that's been done elsewhere globally. I feel that people have this sense that commercial interests of a private entity or institution are often separate from those of society at large. So it'd be great to find out from Owen in a little bit whether they've compared their work to some other stuff that's happened. I'm thinking in the UK context, I think Canada's done some work on this, and also in the Australian context as well. Within the NHS context in the UK, there's this sense, I understand, that patients and individuals really feel like they want a walled garden around their personal data, and they don't really want private companies getting their hands on it, really. So really, I guess it boils down to the question of which groups get to benefit, and is there equitable sharing of the economic benefits versus the risks that are incurred. So yeah, I think that would be very interesting to ask Dr. Schaefer a bit about that in a little while. And I'm just going to stop there, and hopefully we can move on to the third panelist now.
Thank you so much, Sarah, for those really helpful and insightful comments. And you're right, we're on to our last panelist. So to wrap up the kind of formal part of this session, I'd like to introduce Professor Dianne Nicol, who is a distinguished professor in law at the Faculty of Law at the University of Tasmania, and also holds the role of director of the Centre for Law and Genetics, and has published extensively on the intersection of law and biotechnology. Also acted as the chair of the Academic Senate at the University of Tasmania between 2013 and 2019. So, Professor Nicol, over to you.
Thanks very much, Angela, and thanks everybody from Singapore. I'm just delighted to be part of this panel. And I was really inspired by Owen's presentation. I think it's an incredibly important discussion. And as Sarah said, I think it's really an urgent discussion as well. I do recognise that I'm third, and a number of the points that I'm going to raise have already been raised. I felt almost a bit of a relief when Graeme dropped out, because I thought, oh, he might leave some things for me to say, not quite as eloquently as him, but there will be a little bit of synchronicity in what I say with the other speakers. So I'm going to present 6 somewhat unconnected but very short points and thoughts. My first one is that my particular interest in the context of this session is governance of genomic data sharing. And I think genomic data, the issues around that are particularly pertinent for the matters that have already been said. There are vast repositories of genomic data globally. Genomic data flows everywhere around the world. Whole genome sequencing is leading to increasingly sophisticated interrogation of the data, and it's increasingly possible to re-identify the data. So these implications are pertinent to the individual, but they also, of course, go far beyond the individual as well. So there are issues that matter to health data generally, but I see them as being particularly important when it comes to genomic data. And secondly, as for public interest itself, I think we've already had this discussion that it's inextricably intertwined with other concepts such as public benefit, benefit sharing, social license, public trust, and trustworthiness. And these publicly focused concepts sit alongside, I've seen them sitting very much alongside perhaps more individually focused concepts such as informed consent and personal privacy. Thirdly, why is all this important? Why should we take into account public interest? Obviously, there are normative reasons, but there are other reasons that go beyond the normative. And we've seen the consequences when public perceptions that matters are not in the public interest can have serious societal implications. Vaccine hesitancy is obviously one example. Another is the reticence to allow access to health records. In Australia, we saw this with the number of people who chose to opt out of My Health record. And I know there were similar issues in the UK as well. These and other instances show how public sentiment can have a significant impact on what might be seen as the broader public interest. Fourthly, onto my interest, it's particularly research participation in genomic data sharing and biobanking. And there has been an extensive body of work on this, and I just want to refer to some of the work that I've done with my late colleague, Christine Critchley, who tragically passed away last year. Her focus has been on public trust, and it's clear from the extensive body of research that she's done, some of which with me, is that the biggest concerns when it comes to public trust are indeed around commercialization and involvement of private companies. There are also concerns about data flows offshore. Considerations that worry people are privacy, unfair profit, the lack of interest of the private sector in benefit sharing. But people do have trust, at least from the work that we've done. There's a high level of trust of researchers and universities and other research institutes, and a willingness to relinquish control of their own data when they hand it over to people and institutions that they trust. And to some extent, people will trust the choices that these trusted individuals and institutions make about who to share with. But it's all fragile, and it illustrates the need for trustworthy governance, which I'll come back to. It's interesting, though, that governments don't necessarily always fare better than companies, particularly when it's perceived that their main interest is staying in power at the next election, rather than any concept of public interest. So what then is public interest? Yes, it's impossible to define, but because I'm a lawyer, as with all lawyers, we want to try and at least tease out what it might mean in the legal context. And it's certainly a term of art in many areas of the law. I taught for many years in media law, and there is clearly a defense in defamation and breach of privacy and other areas to things that are in the public interest are seen as defensible, but the courts often say the public interest is different from what the public is interested in. But that doesn't mean we shouldn't listen to people when we're trying to work out what the public is interested in. There's a risk otherwise of being overbearing if decisions are made about what should be in the public interest without asking people. So surveys and citizens' juries and focus groups make important contributions in this regard. As for public, yes, there are many publics, each with different interests. Geographically, whether we're talking about local or national or global publics, there'll be differences. The interest of Tasmanians, even regional areas of Tasmania, will be different from national and global public interests. In the current situation we're all living in, we see a rise of vaccine nationalism when we should really be focusing on vaccine cosmopolitanism. Even when calls are made for a more cosmopolitan approach, it's driven more by local interest. So we talk a lot about national interest. Is national interest the same as public interest? Is the interest of Singapore and Australia the same as interest of Singaporeans and Australians? Public interest also depends on the circumstances and the peoples. Indigenous peoples will have a very distinct view on public interest, which may differ from others. In Australia, it would be good if our broader public interest aligned with the interests of our Aboriginal and Torres Strait Islander communities, but I don't think we're there yet. Okay, one more minute. I think I finally must address consent, although over the years, way too much discussion has been focused on consent. I agree that consent and public interest must sit side by side, but I still think that too much is asked of consent and too much store is put in it. I and a group of colleagues wrote in a letter to Science that consent is insufficient when it comes to data release. We need trustworthy governance. As Owen put it, we need what consent does, it gives consent to be governed. From this work, a group of us identified 5 key features of good governance for genomic research. Things like enabling access, compliance with national laws, mitigation of harms, equity in collection, use and benefits, and use for the public benefit, as we termed it, although it could be the public interest. This was a paper led by Kieran O'Doherty, published in Nature Genetics, and I think it really has resonance in the context of this meeting and resonance for health data more generally. So I'm really looking forward to further discussions about how to better accommodate what is this important but quite slippery concept of public interest in health data governance. Thank you.
Thank you so much for that comment, Professor Nicol. And so we've got one comment, we've got one question so far in the Q&A, so I would encourage you to get going there. If you would like to pop on and ask your question live, please just pop your hand up so that we can see that. And we really would like to make this as interactive as possible and as much like a real conference where you would, might stand up and ask your question directly to the panelists. So please do feel free to sort of join us here speaking live if you'd like to. While you just have another moment to think about your questions, I'm going to give Owen an opportunity to respond.
Thanks. I'm looking forward to seeing what the Q&A brings. And thanks for the panelists for those very generous and insightful comments. And it's very useful to see the elaborations on some of these key themes that I think there's some degree of convergence here. So I'll just try to quickly reflect on some of those areas. I mean, one is this this question of, I think we're all reluctant to define public interest precisely. I think that's fair enough. So I actually, in the talk at the beginning, I kind of said I would give a definition, and I didn't really fulfill that promise in hindsight, and maybe that's okay. That we're instead trying to give a broad framework of public interest, and then through pragmatics, through contextualization, try to figure out what it might mean in one scenario. But nevertheless, there is going to need to be this pragmatic decisions made by governance bodies, by data access committees, and so forth. But whether or not a given request for data, et cetera, is in the public interest. So we can't completely avoid that question. So in that spirit, I think another thing that was pointed out was that this idea of the changing landscape, that the landscape is changing so quickly, means we need to revisit this question constantly, right? And this idea of governance reflexivity is something, and I think governance studies is a very important aspect, agility, reflexivity, and to ensure that things like data access committees, IRBs have that characteristic is going to be crucial. But the question is, of course, how to ensure that. And one way is this notion of sort of public engagement and working with publics, because as the technological landscape changes, perceptions also change. And then related to that, another thing that is important but also shifts is this question of trust. And this relates a little bit. So Sarah was asking about what's the difference maybe between Singapore and other findings. And there's this question of to what extent do individuals and groups put trust in the governance structures to promote the public interest in ensuring responsible data use and sharing. And this will depend, as I noted, to some extent on the extent that the attitudes people have towards different entities. So, for example, one thing that our research reflected, and actually is also reflected by certain international surveys, was in Singapore there is unusually high trust in government compared to other countries. So when we did this kind of research, okay, who should really be responsible for ensuring this public interest, and the top answer was I think Ministry of Health was the top answer among our respondents. And you wouldn't get that answer, say, in America. I don't know, probably not in Europe or Australia. And that reflects a different sort of attitude to government. And that's again reflected in other international surveys. And that's important because, in addition to ensuring that practically speaking, people are going to accept the regime that's put forward, it does reflect to some extent the relationship people have with their government versus, say, private entities. And just on the other side of things, in terms of relationship with companies, yes, certainly the Singaporean population was very similar to the international community. There's a lot of suspicion of private sector. This seems like a universal, maybe not human trait, a universal social trait in the current context. We'll see if this shifts. I'd be interested. One thing that happened after COVID-19 was that perceptions of pharmaceutical companies became much more positive. So one thing in terms of dynamism is to think, well, are people going to, but then we'll see if that shifts back again. So I'm interested to see if attitudes towards companies and how much they're acting in the public interest changes in this COVID-19 context. But one thing just to keep in view is that, whether even if it increases, there's still this big gap. And the governance structures that we put forward, and something that was very hard to see Patrick Tan's introduction discuss, was that there is a recognition that to reflect this, not just the kind of difference in trust, but also the underlying challenge of ensuring private companies act in the public interest, there does need to be this extra level of scrutiny. This extra level of attention by data access committees and other governance bodies. And so I'm looking forward to see how in Singapore this is carried out. And I look forward to seeing, in this discussion, maybe we can see a bit more in terms of how these governance structures might be designed to promote public interest, to be responsive and reflexive, while in promoting socially valuable research that really can advance human health and human well-being. Okay, I'll leave it there. Maybe we can move to Q&A.